Good morning, everyone. Thanks for joining us. My name's Tim Allen, and I'm here today, virtually, with my colleague Priya Saran. Historically, when we host these HR review seminars, we do so in person, in a large room, often at a convention center, where we spend time together and enjoy breakfast. These days, of course, sharing a room with hundreds of people is not on the cards. So we've taken our presentation to you by Zoom. We have roughly 2,000 people registered with us today. And while we're very happy to have all of you with us via Zoom, we also look forward to the day we can get together in person. Now, let's turn to today's topic. The title is Blurred Lines, When Personal Interests Become an Employer's Business. I'll start us off today by tackling the topic of privacy, productivity, and work from home. Specifically, I'll address monitoring and managing employee performance and productivity during work from home caused by COVID, and how that ties into considerations for your remote work policy. I'll then turn it over to Priya, who's going to address two topics: the refusal to wear PPE, personal protective equipment, and freedom of expression as it relates to COVID-19. The format for the morning will be as follows. Priya and I will be presenting from 9 to 10 a.m., and then we'll answer questions until 10:30. If you have a question for us, please type it into the Q&A box, not the chat box. Again, please type it into the Q&A box on your screen, not the chat box. We'll do our best to answer as many questions as we can in the time that we have this morning. But if we don't get to your question, please reach out to us after the presentation. Finally, a recording of this presentation and the slide deck will be available on our website in a day or two. So with that, we're ready to go. So let's get started. As I mentioned earlier, the first topic we'll be addressing is productivity, privacy, and work from home. So here's the entrance to the first one. Many things are the same with remote working during COVID as they were working in the office pre-COVID. Employees are still required to work, and employers are still required to pay them, track their hours, pay overtime if it's required, respond to harassment complaints, all those fundamental parts of the employer-employee relationship. During COVID, we've seen workforce productivity become an even more heightened concern for employers, as a lot of employees are working remotely. Just like before COVID, an employee can be disciplined or their employment can be terminated for low productivity while they're working from home, subject to a number of different considerations that we'll go through this morning. There are a few extra challenges and considerations during COVID. For example, the workforce productivity may be harder to track, so it's important to consider what metrics you're using as an employer, rather than use hours, for example. While everyone's hours might be more erratic during COVID, it might make more sense to be using some other measure of output. During COVID, there could also be other explanations for a drop in performance, such as childcare obligations that came up with the school closures. Just like pre-COVID, in a unionized workforce, performance issues should be managed in accordance with the collective agreement, which can mean going through the progressive discipline process before an employer can assert cause for termination. In the non-unionized workplace, an employer may still have a progressive discipline policy they'd like to work through, or they can sidestep or forego that progressive discipline and performance management process and proceed to a termination without cause, pardon me. In a termination without cause, remember that there will be certain obligations to the employee if they're entitled to termination pay and severance pay, or if they have other entitlements under contract or under common law. As an employer, if you are implementing discipline or terminating for cause, it's important to be able to establish these three things that I'll address briefly here. So first, that the expectations, concerns, and consequences were all clearly communicated to the employee. Second, that the employee was provided sufficient time and resources to improve. And third, that the final warning states that the next violation will result in the termination of employment. And these should all be familiar from before COVID, because it's the same factors you would have seen there. This is all important from a legal standpoint to justify the discipline or the termination for cause. It's also helpful to keep in mind as an employer if you're attempting to course correct performance. All of these steps could, hopefully, in some circumstances at least, lead to an improvement of performance. It's really important as an employer to get credit for following the process we just covered, or some of the processes we just covered. It's not enough just to have great processes in place. You need to be able to demonstrate as an employer that you followed them. The first question an employment lawyer will usually ask you when you're looking at discipline or a termination for cause is, well, what documentation do you have in place? Because that documentation is how you'll be able to prove that you followed a good process. My first Zoom hiccup of the day. We'll turn in a second to monitoring employee performance in more detail, but just before we do, I wanted to very briefly address two issues that come up more so during remote work, which has come up more during COVID. First, there is consistency with how the employee has been treated. One of the defenses to a cause case or to discipline is condemnation. In other words, that the poor performance was previously permitted and therefore accepted or condoned. It's important to view the remote work environment as an extension of the workplace. If the employer condoned low productivity before, so when work was happening at the office, it could complicate discipline termination when the employer is looking to terminate for that same poor productivity later on. Another consideration can be how other employees are treated. So consistency. An adjudicator may look at how other employees have been treated with a temporary decline in their performance. Another concern during COVID, and this is the last one we'll address here, is that there could be other explanations for a drop in performance. For example, are there childcare obligations or an elderly parent at home? It may be helpful to ask the employee about the reasons for their poor performance before moving to discipline or termination to screen out potential human rights related issues like childcare, which could complicate discipline and termination. Generally, an employer has a right to implement a policy to monitor productivity through performance. What makes sense for each employer will depend on the individual business and their workforce. You'll see on this slide a number of potential options listed, and we've seen all of these implemented. Things like computer cameras or software that tracks when where an employee spends their screen time, or even that takes random screenshots during the workday. Keystroke logging, GPS tracking. There are a whole host of different ways to try to come up with an effective way of monitoring employee performance. I'm going to address next a few of the considerations from a privacy standpoint that employees may have with respect to these different employee monitoring systems. As I mentioned on the last slide, while an employer has a right to implement a policy to monitor productivity through technology, it should also consider if there's a privacy right or interest engaged. In Ontario, there is no general private sector privacy legislation, unlike in BC, Alberta, and Quebec. In provinces where they do have private sector privacy legislation, the collection of employee personal information, which can be defined broadly, may be required to be reasonable and may require employee consent. So as a first step, it's a good idea to consider any legislated privacy concerns. Absent legislation, there can be other privacy concerns. And what I'll address briefly here is something called intrusion upon seclusion, which is a tort. The Court of Appeal in Ontario has recognized that this tort includes physical intrusions into private places, as well as listening or looking with or without mechanical aids into the plaintiff's private affairs. So that could include, theoretically, employee monitoring by an employer. I'm going to very briefly address this case because usually talking about cases is the most interesting part of these HR reviews, at least for some lawyers. The case that's the seminal intrusion upon seclusion case in Ontario, it did involve something at the workplace, but it was between two employees. And in this case, the plaintiff and the defendant didn't know each other, but they did work for different branches of the same bank. And the defendant had formed a common law relationship with the plaintiff's ex-husband. The plaintiff brought an action for damages against the defendant when she found out that the defendant had accessed her personal banking information 174 times over a period of 4 years. So it's an example that even though there's no privacy legislation that was applicable here, there was a potential cause of action, a legal cause of action. The implementation of a new monitoring system could also give rise to a constructive dismissal claim for an employee. Remember that constructive dismissal is established at law if an employer makes a unilateral and substantial change to an essential term of employment, which is a bit of a mouthful. There's limited case law on how this applies to privacy concerns, but we'll take a closer look at one pre-COVID example. In this case, Colwell and Cornerstone Properties Incorporated, the employee quit her job and she alleged she had been constructively dismissed after she found a secret video camera that had been installed in her office and only her office. The employee's boss claimed that the camera had been installed there due to a concern about theft by maintenance staff. The court, however, did not find the boss's reason to be plausible. The employee did not store any money in her office. It wasn't her who was being investigated for theft. It was the maintenance staff. The employee was actually the one who was responsible for managing the maintenance staff, but she wasn't advised of this concern or of the potential monitoring. And there were a list of other examples in the case. For example, the camera wasn't turned off during business hours, even though you would think that if there was a theft by maintenance staff, it would occur after business hours. Looking at all of this together, the court held that the boss had provided an implausible explanation, and that rendered his conduct, so the secret video camera, unacceptable. Although the camera was not in and of itself unacceptable employer conduct. Given that there was the implausible explanation, the court found that employee privacy was violated and the workplace was poisoned. The quote, which you'll see on the slide there, was "all trust had evaporated." And this amounted to a constructive dismissal. So the employee was successful in her case, and she was ultimately entitled to 7 months of pay in lieu of notice based on the constructive dismissal. In a unionized workplace, there can be extra considerations for an employer because the employee monitoring itself may be the subject of a policy grievance. Labor arbitrators have recognized a privacy interest even in the absence of legislation, so specific private sector privacy legislation. And in order to justify that the monitoring is reasonably is permissible, it has to be found to be reasonably necessary to accomplish a work-related purpose, and a lesser means of monitoring would not have been adequate. So if you remember that case we talked about a second ago with the secret video camera, was there really any reason the employee couldn't have been advised about the secret camera? Or did it really have to be on at all times? Could it have been limited to after regular business hours? The last area I'll talk about here before turning it over to Priya is a remote work policy. It's important to consider a remote work policy to mitigate some of the risks we talked about and cover off some of the best practices. So we've been spending a lot of time with employers, especially during COVID, to look at what that means in more detail. In a remote work policy, it's important to address privacy and monitoring issues. So reiterating that an employee has no reasonable expectation of privacy and setting parameters on the personal use of work technology. as well as providing express notice if any monitoring technology will be used or may be used, and to what extent. That way, the secret video camera won't come as a surprise to the employee later on. In a remote work policy, there are a number of other considerations, including setting out criteria from working from home. For many employers, they've implemented an expanded remote work policy during COVID, but some of that might continue after COVID. So your remote work policy can address if there will be criteria during COVID, if those change after COVID, establishing or reiterating that there's a right of an employer to recall the employee to the workplace, including a restriction on where the employee may perform work, for example, limiting them to their home, potentially for privacy reasons, or confidentiality reasons, I should say, or limiting the province of their employment. For example, you may not want your employee to be working in a ski hill in BC, except if your business is located on a ski hill in BC, in which case, good for you. Your remote work policy can also address technology and expenses incurred in the performance of remote work. Is the employer going to be paying for any of it? It can cover off confidentiality and security protocols, so how employer confidential information should be handled. And lastly, although there are other considerations you can include as well, an expectation about tracking hours of work. One of the worst surprises for an employer is a very large overtime claim where the employee submits their own handwritten journal of their hours of work. One of the good ways to preempt that or defend against it is having an expectation of tracking hours of work. And that can be included in the remote work policy because it's a lot harder to track hours of work when an employee is not at work physically. So at this point, I'm going to turn it over to Priya to talk to us about refusal to wear PPE.
Thank you, Tim. Good morning, everyone. As Tim mentioned, I will be talking to you this morning about two other topics that we've been getting a lot of questions from our clients about. The first, what to do when an employee refuses to wear PPE. And the second being where the line is between an employee's right to freedom of expression regarding COVID-19 and an employer's right to protect its interests. Well, it looks like I've lost my presentation. I'll just keep going while that's getting reloaded up there. So let's start with refusal to wear PPE. The starting point here is that employers have a right to determine what personal protective equipment is required to maintain a safe workplace. This is so that employers, you, can meet your obligations under occupational health and safety legislation in the context of COVID-19. What does this mean? This includes mandating the use of masks, gloves, and face shields, for example. If an employee refuses to wear required PPE, then you have a right to discipline those employees. This is all, of course, subject to one major caveat or exception. An employee does not have the right to refuse, that they can refuse to wear PPE if they have a valid human rights related reason. These might include that the individual has a disability or that there's a religious reason that they can't wear that particular PPE. Very recently, there was actually a case where someone tried to bring a case at the Human Rights Tribunal asserting that they shouldn't have to wear a mask because of the protected ground of creed. The applicant claimed that my creed, this is actually quite interesting, my creed requires that I do not blindly accept what government or agencies claim, mandate, or enact into laws. Instead, it's my civic duty to be critical of government and their decisions. So this is what the individual claimed was their exception under the Human Rights Code. In this particular case, the applicant claimed that he was discriminated against when he was denied services for refusing to wear a mask. The Human Rights Tribunal rejected his claim because, according to the tribunal, it did not engage his religious beliefs or practices, and this really just amounted to political opinion. And the tribunal made it clear here that your mere political opinion is not a protected ground under the Human Rights Code. So when we're talking about refusal to wear PPE, at this point in time, most jurisdictions and provinces in Canada have some form of legislation in place that requires individuals to wear masks indoors, whether in public spaces or in workplaces. In addition to legislation that requires businesses to ensure that masks are being worn, this is also a requirement on individuals. So there's the two different aspects to it. In Ontario, both are in place. In BC, it's required in public indoor spaces and recommended in workplaces. In Alberta, it's mandatory in both public and private workplaces, subject to exceptions. So the exceptions are relatively similar across the different jurisdictions. Where there is a medical reason that an individual cannot wear a mask, that's a key exemption. And in Ontario, the other key exemption, of course, would be if you can maintain a distance of 2 meters while you're inside in an area that's not open to the public. What's really interesting about the legislation, though, in Ontario is that it uses the wording "not necessary" to provide that it's not necessary to provide evidence to support entitlement to an exemption. And this is something that comes up because employers are always asking, well, can I ask for evidence to support the fact that this person is entitled to an exemption? And so some people have interpreted the regulation to suggest that maybe they do, in fact, not have the right to ask for medical documentation. But that's actually not the case. Right, so we've got our slides back up and running. Sorry for that, people. Okay, so if an employee is the one who is seeking an exemption from the requirement to wear PPE, then this is just like evaluating any other form of accommodation under human rights legislation. The employee has to establish the need for it. So then you're going to request medical documentation, and that documentation should confirm the existence of disability, establish what restrictions and limitations related to the disability will prevent them from being able to wear the PPE. And that documentation should allow you to determine if the employee can still wear PPE with an accommodation. So for example, you want to be looking for whether or not there is an alternative that's reasonable. Can the individual wear a mask that's made of different material? Or can they take frequent mask breaks? Will that allow them to continue to work with the PPE in the environment? Okay, so if the employee comes to you and they tell you that they have a legitimate medical condition, they provide you with some documentation, what is the employer's obligation? You need to determine then if you can accommodate the individual to the point of undue hardship. And here's that big question, what does that mean? What is undue hardship? In Ontario, there are 3 considerations that the Human Rights Tribunal would consider when assessing whether or not an accommodation would amount to undue hardship, and those include cost, outside sources of funding, and health and safety requirements. Now, these factors are very similar to other jurisdictions, and it's the same list of factors for the most part that will be taken into account. What's important to know here is that it's a hard threshold to meet, and that mere inconvenience or expense is not going to be enough to establish undue hardship. Frankly, unless you have health and safety considerations, it's going to be very difficult to meet that standard. So let's talk about the health and safety standards. So the right to freedom from discrimination must be balanced against health and safety. And if you're considering waiving a requirement to wear PPE, you should consider whether this would cause a significant risk to others, including some of these factors. So how severe would the harm be if it happened? How likely is it to occur? Is it a real or speculative risk? And who would be affected? So I would suggest that in the context of COVID-19, the risk could indeed be significant. There's an unlimited number of workers who could be affected if COVID were transmitted in the workplace, or if there were to be an outbreak. So then you might ask the question, okay, do I have to let the employee work without a mask because of the exemption in the legislation? Well, the answer is no. But let's first look at, any of these other possible accommodations first to see if there's a way to have them in the workplace without posing an unacceptable level of risk. So could you relocate the employee such that they can maintain a distance of at least 2 meters from their coworkers? Can you temporarily assign them to a new position? Is a work from home arrangement possible? Can you implement plexiglass or impermeable barriers between them and their colleagues? If any of these things are possible, perhaps their inability to wear the PPE is not as significant of a risk. But if none of these options are feasible, then a leave of absence may be the only appropriate option until their medical restrictions or the public health requirements change. So enforcing PPE policies in the workplace in order to maintain health and safety seems relatively straightforward, right? Now we're going to move on to our final topic of this morning's seminar and talk about what rights an employer has with respect to their employees' conduct on the weekends, their lunch breaks, or even on social media as it relates to COVID-19. The general rule is that the employer is not the custodian of an employee's personal character and conduct. What they do in their private time is their business. Maybe. There are circumstances where off-duty conduct or an individual's personal comments may be subject to discipline or termination. But the caveat here is that their conduct must negatively impact the employer's legitimate business interests, or there must be a nexus between the employee's actions and the employment relationship. So the key questions you need to ask here are, is the conduct work-related, or is the conduct going to affect the work relationship? So when we're looking at discipline for this type of conduct related to freedom of expression or off-duty conduct, here are some of the 3 main ways that discipline could be appropriate. If the individual's views expressed or their actions are fundamentally at odds with the duties or responsibilities of the position, if the off-duty conduct or comments causes other workers to feel unsafe or poses an unacceptable risk, or if the comments or conduct harms the employer's general reputation, their products, or their workforce. Now, in December and January of this past year, there were a number of cases that were widely reported in the news in Canada, where what employees did in their private time had an impact on the employer or really affected its interests. And this very issue was front and center. So for example, it's no secret that a number of politicians were caught traveling over the holidays despite the stay-at-home orders and their own government's recommendations. This had some serious blowback for them. Another great example is the former singer of the national anthem for the Vancouver Canucks, who attended a freedom rally in Vancouver to protest the tyranny of COVID-19 restrictions. He also refused to sing the gender-neutral anthem that was imposed by the government. And these things all led to the severance of his employment with the Vancouver Canucks. So let's look at each of these 3 forms of conduct in a little more detail to understand what we're talking about. So the first one, as I mentioned, is where the individual engages in actions that are incompatible with their position. So what you need to consider here is if their personal views or actions are interfering with the performance of their duties or inconsistent with the nature of their position. In the context of COVID-19, a great example would be where you have a healthcare worker who is discouraging the residents or patients from wearing a mask or from being vaccinated. not in the context of COVID-19. There are a couple of other great examples that I can provide you with to explain, this inconsistency. So there was an older case, it's a 1995 case, where a psychiatric nurse developed a relationship with a patient. And this was clearly found to be professional misconduct by the College of Nurses. This conduct that the individual engaged in was inconsistent with their position, jeopardized treatment of a patient, and breached the standards of employment. Another, somewhat clear-cut example is where, this is an old banking case, an individual who was a bank teller developed an extracurricular relationship with a bank robber. And this was found to jeopardize the interests of the employer, and dismissal was justified. So the second area where an individual's expression can lead to trouble is where it impacts worker health and safety. So again, the starting point here is that the employer has a duty to take every precaution reasonable in the circumstances to protect the health and safety of a worker. During the pandemic, this means reducing or preventing the transmission of COVID-19 through implementing policies and practices related to masking, screening, or physical distancing, for example. When employees don't comply with the health and safety policies, not just like, just like the PPE conversation we had earlier, discipline or termination is appropriate. So for example, last year, a unionized security guard was dismissed for cause because she knowingly went to work after testing positive for COVID-19. So this was arbitrated as a decision, and the termination was upheld. Similarly, there was a case this year where, and this one's actually kind of interesting, an individual breached the hospital's COVID protocol by bringing pizza into the workplace to share at a social gathering. They disregarded the screeners at the hospital's door and also defended a vendor who didn't want to wear a mask when entering the hospital. So this person was discharged for cause, the suspension was upheld, and the discharge was overturned. So when and if these scenarios arise, it's important to be aware that other employees may be impacted. They may feel threatened, they may refuse to work. This could happen, even if an employee becomes aware that one of their colleagues has been engaging in risky behavior after work. So for example, they broke the stay-at-home order and went to an illegal party, or that they went to a gathering and weren't wearing masks. If these concerns are brought to your attention, you have an obligation to investigate. This is going to come up in a couple of ways, right? So the coworker reports feeling unsafe because of another employee's disregard for COVID-19 rules and requirements, but it could also arise, this duty to investigate, if a coworker claims that they're being harassed for their own COVID-19 related views or for following your policies. And this is something that we've absolutely seen come up. So even if an employee doesn't come to you and complain, you should still investigate if you become aware of off-duty conduct that has a nexus to the employment relationship, because these behaviors could ultimately put the rest of your staff at risk. So what are some examples of the risky behavior I'm talking about? Acting contrary to public health guidelines, making anti-mask or anti-vaccine posts and commentary, or if someone is symptomatic, refusing to be tested for COVID-19. If any of these things are occurring, you may want to investigate further. I'm sure many of you within this topic area read about the nurse from London, Ontario, who traveled to Washington for a rally in January 2021 and espoused views that COVID-19 is a hoax. She was fired for cause by the London Health Sciences Centre after an investigation into her activities. And those activities in her case included speaking out against wearing face masks, speaking out against the lockdown measures, and attending the anti-lockdown rallies. So in this case, she traveled despite the fact that the Canada-US border is supposed to be closed to non-essential travel. And she made comments that were incompatible with the nature of her role at work. Okay. So the third category or area of expression or off-duty conduct that we're concerned with is where those comments or conduct cause harm to the employer's business or reputation. So we're looking at, for example, whether or not there's public controversy. Have you been getting negative press about it? Is it damaging to your client base or harmful to them? And here you only need to show that it's potential harm, not actual harm. Again, this is an area where there has been a lot of press and a lot of interesting cases, just to highlight the point. For example, over the holidays again, Ontario Finance Minister Rod Phillips was effectively forced to resign after the news emerged that he had vacationed in St. Bart's. Alberta's Municipal Affairs Minister, Tracy Allard, who was vacationing in Hawaii, she also resigned. A hospital CEO resigned over a trip to the Dominican Republic over the holidays. The key thing here is that the actions impact the employer or they're related to employment in some way. But before you make any disciplinary decisions for one of those three types of incompatible conduct, health and safety risks, damaging to your reputation, one of those types of things, you need to do an investigation and you need to consider what actually happened. Were there any mitigating factors or circumstances? And is there any medical or human rights related justification for that individual's conduct? So when I talk about mitigating circumstances, here's another example. So with respect to the politicians who were traveling over the holidays, one of those politicians traveled in order to attend the funeral of a family member. That might be a mitigating circumstance that you take into consideration before making a disciplinary decision. Okay. So overall, before we make a decision as to whether or not we're going to discipline or discharge someone for their off-duty conduct, we're going to consider and assess a number of factors. We're going to do an investigation. So we're going to consider what is the actual risk to the customers, the public, or other employees? Have coworkers expressed a fear of working with that individual? What is the extent of the reputational harm caused? Like, has this person been associated with you on social media? Like, do they disclose where they're employed? And do other employees in the workplace engage in similar conduct, or is it just that one individual? And the last one I would highlight here is, do you have a social media policy or a COVID-19 policy that specifically addresses this type of behavior? You can make it an express part of your policy that an individual can be terminated or disciplined for failing to adhere to the public health directives. And if you don't have one in place, this is something that you should seriously consider. So the last thing I would say here on this point is that the decision to discipline or discharge someone for failure to follow public health guidelines can be difficult, especially if the guidelines are not entirely clear. As we all know, the rules and regulations have been changing rapidly. And there's a patchwork of legislation out there. It may be confusing to an individual as to what the actual rule was. So, for example, we like to joke, stay at home unless you need to go out for shopping or exercise or, whatever the list of things is. The second thing here, make sure that the punishment fits the crime. Is this the situation where someone came to work knowingly with COVID-19? Or is this the situation where, someone had ordered pizzas for their coworkers after a meeting? If you're unsure about whether or not you should be imposing discipline or terminating an employee for their views or conduct related to COVID-19, we're always here to help, seek some legal advice. And with that, I will open the floor up to questions. And I think I'm going to turn this one over to my colleague, Tim.
Hi there. So thank you all for sending in questions. Please feel free to continue to do so. We're still monitoring the Q&A. I'm going to start with a few questions about the first part of the presentation. So I'll read out the question and then we'll talk about the answers to them. So first question I have here is when you say give the employee sufficient time to improve, what are the best practices around that timeline? An answer I always try to avoid giving, but inevitably end up giving is it depends. And really it does. There's no hard and fast rule to how much time should be given. It'll depend on the context. So for example, if you have an employee who's showing up late, that's not going to require nearly as much time to improve as an employee whose sales record isn't very good. So it'll depend on the context. Next question I have here is, must you state will or can you state may result in termination? And that would be with respect to a final warning. The risk in saying may is that an adjudicator may not ultimately be satisfied that there was really that final warning that justifies the termination for cause at the end of the day. So that would be the risk in using more equivocal terms like may. Next question I have here is, does the employer need to inform the employee that he or she is being monitored? As a best practice, it is a good idea to have a reference in the policy documentation to make them aware. If you don't, and there may be reasons you don't want to, but if you don't, there are a few of the risks we talked about earlier, right? So that's the risk potentially of the constructive dismissal claim, or at least a higher risk of a constructive dismissal claim, the intrusion upon seclusion or a policy grievance. This is all particularly true if the employee can demonstrate there's a reasonable expectation of privacy over the device that has been compromised by this employer monitoring system. So the level of risk is going to depend on what kind of monitoring is being used, but there could be a risk with not getting the employee to be aware of it. Next question I have here, and I'll turn it over to Priya after this question, is if there is a constructive dismissal, will notice, so notice entitlements to the employee on termination, will they turn to common law or fall to the termination clause in the employment contract? Generally, if you have an enforceable termination provision in your employment agreement, and I'll come back to that in a second, notice ought to be based on that contractual entitlement rather than the common law. If you didn't have an enforceable termination clause, then notice on termination or on constructive dismissal would be based on the common law. Now, if you've been an employer in Ontario over the last 15 or 20 years, you know that enforceable termination clause can be harder said than done. So that adjective enforceable is important there, but it is a good defense, and having an enforceable termination clause in your contract is always a good idea. We have seen arguments that a constructive dismissal constitutes a repudiation of the employment contract such that the employer shouldn't be able to rely on the termination clause, but having the termination clause is a very good defense to start with. With that, I'll turn it over to Priya. Oh, she's waiting for a question. I'll do one more first. Next question I have here is, how do you defend you must only work from your home if the employee is fully functional working from a ski hill? It's a very good question. It's one that we've dealt with a number of times. I've had employers, a lot of employees want to go work in BC or out east, so different province. I've also seen different country a number of times. And the defense that we've come up with employers is there can be a whole host of different legal implications to an employee not working in their normal province of employment. So I mean potential tax implications, mostly with different country, and potential employment standards implications. So if your employee went off and worked in BC and they normally work in Ontario, at some point BC employment standards could apply, and that requires or has very different entitlements with respect to, for example, overtime. Just briefly, because we're talking about working from home it doesn't necessarily mean in a different province, right? If you're working in the same province, the same Employment Standards Act clearly going to apply. There could still be confidentiality concerns though, right? If and when coffee shops open up again, you don't really want your employee working from a coffee shop with a whole bunch of confidential information. So that could be a reason as well. So I'll turn it over to Priya now.
Thanks, Tim. All right, so I have a list of questions here. So the first one is, what proof can an employer request from an employee who does not want to wear PPE due to a human rights ground? So as I said during my presentation, you're entitled to treat this the same as any other request for accommodation. And that means that you can ask for specific medical documentation to support their request that sets out their restrictions and limitations. The second question that I have is, can you discipline employees for not completing workplace pre-screening questionnaires before arriving at work? And that's presuming there's a pattern of not doing it. And the answer is yes. I mean, this is something that employers are required to do by legislation. And you know, if you're implementing this for the health and safety of your workers, you have a right to mandate it. And if your employers are, you know, repeatedly failing to do it, you absolutely can discipline for that. Because one other thing I should point out here is, you know, you also have as an obligation as an employer to maintain the records so that if you get audited by the ministry, you can show that these screening records have been maintained. So just keep that in mind. The third question that I have here is, what happens if an employee does not want to wear a mask because we have plexiglass in place? Regardless of whether or not you have already taken those other measures, you can impose a mask policy. And so long as there is no exemption that applies to the individual, you can require them to wear their mask and you can discipline if they're failing to wear PPE. Now, Tim, should I do another one or should I turn it back to you for a couple? All right, I'll just do another one. Okay, so question 4, if an accommodation cannot be made to the mask exemption and the employee must request a leave of absence, can an employee apply for an EI leave, I guess for EI benefits, so they have a source of income? Yes, absolutely they could, and they will likely be able to apply for EI at that point. Tim, back to you.
Thanks, Priya. She would have kicked me out of the table if we were sitting beside each other. I had a quick addition to the last question I answered, which was about working from the ski hill, right? What's the employer's justification for not allowing the employee to do that? And one point I would add to it is that you could be looking at potentially, it's not only employment standards law that might be different, it could be things like Occupational Health and Safety Act. There's a different one in each province. Turn to the next question. In terms of a work from home policy, where does an employer and employee determine there are breaks, so the employee has certain breaks throughout their day, could an employee argue that they were on their break when an employer monitored or conducted a screenshot of their computer? So I guess what we're looking at here is really a defense to an employer claiming the employee was not working because the employee monitoring showed they were not working. I think the starting point here is it's important to consider that when developing your employee monitoring system, if you are developing one. It's hard to find a perfect system. And if all you have is random screenshots throughout the day, that on its own could be defensible, right? Because it doesn't necessarily show the employee not doing work at certain times. I was reading an article the other day, I think it was in the New York Times, and it was a reporter describing his experience with an employee monitoring system. He signed himself up for it and gave his boss access to it. And he left open Google Docs for big portions of the day so that whenever there was a screenshot taken, it looked like he was working on Google Docs. So that's one of the considerations for your employee monitoring system. But with respect to breaks specifically, because it's a good question, consider having the break times logged, right? If you know that an employee is tracking their hours and recording their break times for those tracked hours, when the screenshot shows that they're checking Facebook at 3 p.m. and their break was at 2 p.m., you know that they were not on break at 3 p.m. So that would be a good way to do it. It's also a good idea to have those hours tracked generally, because that ties back into the overtime issue we talked about briefly before. Next question I have here is, and I'll turn it back over to Priya after this one, is could you comment on handling WSIB claims when an employee alleges a work-related injury while working from home? It's another good question. Generally speaking, WSIB will apply to a work-related injury, even if that injury is incurred at home. The issue will be determining if that injury is really work-related. So is it, for example, an ergonomic strain or carpal tunnel, right? That kind of thing. As anyone with any experience with WSIB will tell you, the line for work-related versus not work-related can be very gray sometimes. So it's important to take a close look at that. But ergonomic strain is a good example of something that has a good chance of being work-related. So I'll turn it back over to Priya.
Thank you, Tim. Right, so there was actually an add-on to the last question that I answered, and the question is, what if the work from home arrangement, where an individual is working without a mask, means that they will have reduced hours? And my answer to this would be, if you can demonstrate that this is the only reasonable accommodation available, because there were no accommodations that would have allowed them to continue to safely work on site, then this would generally be permissible. The next question I have here is, what if an employee comes to work after knowingly being exposed or around someone with symptoms? Okay, so this is similar to that one case that I talked about where the individual was discharged with cause. If someone's been in close contact with someone with COVID and they come into work knowing this, and you have a policy that makes it very clear that they should not be coming into work, then this is absolutely a disciplinary situation. But the other thing here is you should have screening measures in place, and theoretically, if someone has been exposed to someone with COVID but doesn't have any symptoms themselves, that would be caught by your screening protocol. Okay, so the next question I have here is, what about the issue of other employees complaining about coworker conduct when the coworker posts pictures of themselves in close contact with others, socializing on the weekend, not wearing masks and in close contact? So this is exactly the scenario where I was suggesting that there hasn't been a complaint, but you become aware of some off-duty conduct that's concerning to you. I think that this is exactly the scenario where you would want to investigate further to make sure that that person's not posing an unreasonable risk to the rest of your workforce. And in this scenario, if say we're living in Toronto and we're still under stay-at-home orders, if that person is breaching regulations, this could be a disciplinary offense. Okay, I'll do one more and then I'll turn it back to Tim. So the question is, in the employee's private time, if they get another job as a delivery driver and we feel that is risky and makes coworkers feel unsafe, can we ask them to stop or risk losing their job? So in this scenario, I would suggest that you could probably put them on a leave of absence if you don't want them in the workplace. And you could alternatively tell them that they have to make a choice, and if they're not willing to work at only one location, that you're going to terminate their employment without cause. Back to you, Tim.
Thank you, Priya. So I got one question to go back to an earlier question, so we'll start there. The question is, can you review the answer again for employees who move out of a regular commuting area? Kind of what happens when their office reopens if they still want to work from home? And the comment added here is, we expect all employees to come back to an office and we should not care where they have moved to. So this kind of gets into what happens after COVID, which would be a very nice time. There's no requirement for an employer to guarantee an employee work from home. Work from home absent COVID could be for example, an accommodation, or it could be a part of a contract of employment, whether implied or explicit. But if that was not there before, it shouldn't become there through COVID. But I think this ties back into the remote work policy we touched on before, because there could be an argument that an employee says, hey, I can do my job from home. You let me work from home before. That should continue post-COVID. There's no reason to change it. So that's one of the reasons a remote work policy can be helpful, to make it clear what expectations are going to be post-COVID. Next question I have here is, can you require that a pre-screen is completed before the employee's start time? I think it's actually a good idea to get the pre-screening completed very near the employee's start time, just to make sure you don't want it completed 4 hours before, for example. I think it's perfectly fair to require it before the employee gets on the employer's premises, or very near that time. It's different areas in Canada have different requirements with respect to pre-screens, but there can be a limit on who's allowed to enter your workplace. And if there is, it would be a good idea to have it completed before the employee starts work. Next question I have here is getting into positive COVID test cases, and what happens when an employee has tested positive, which we're seeing a lot of recently, or that kind of question. And the question I have is, if an employee is stating they're COVID positive and requesting a leave, can we request they get a test and provide us with the results? This question is particularly for cases where employees have already had a COVID leave and said they were positive last year, and now they are taking the same position this year. So if I read between the lines here, it sounds like we're skeptical that this employee is legitimately testing positive, and they may just want time off work, or that's what it sounds like to me with this question. If an employee is requesting a leave of absence because they say they are COVID positive, presumably that employee has obtained a test. And in Ontario, in order to be eligible for the leave of absence called infectious disease emergency leave, an employer is allowed to request evidence reasonable or appropriate in the circumstances. The circumstances described here, that was me trying to make it clear it's a bit fact specific, but the circumstances here make it look like it might be appropriate to ask the employee for their positive COVID test result. Now, of course, an employee doesn't actually have to necessarily test positive for COVID. In order to be looking at a leave of absence, they could have been in contact with someone who tested positive, for example. It's a lot harder to require evidence in those circumstances. But given that this employee seems to be saying they tested positive, it seems a lot more reasonable in those circumstances. Priya, I didn't give you much of a lead in, but turn it back over to you.
Thanks, Tim. I see that we actually only have 1 minute left to 10. So it seems that perhaps I need to wrap this up.
Well, actually, I think we've been talking very quickly, or at least I have. So we do have a bit of time left.
We still have a couple minutes? Okay, great. Well, then I will take a couple more questions before wrapping up. Yeah, all right, great. So the next question that I have is, if the only option related to accommodation is a leave of absence, does it have to be paid beyond what paid time off the employee is entitled to? No, you don't have an obligation to pay someone when they're unable to work. They may have other options available to them if the absence is COVID related. The next question that I have is, what if an employee books vacation and it gets approved, but the employee does not disclose that they're leaving the country until a couple days before the vacation starts? This is an interesting one, especially given what transpired over the holidays with a number of other individuals. I would say, one thing we need to look at first here is whether or not the employer has a policy that deals with this situation around travel. The second thing is whether or not the individual works in a job where they can work from home. And I think it depends on what the applicable regulations are in the jurisdiction where this person's working. So if they're not supposed to be traveling and they work in an environment where, for example, with government or perhaps even healthcare, where the recommendations are not to travel and they do travel for pleasure, this could be a disciplinary issue.
Just to pick up on the traveling, because we have seen this, especially as COVID drags into, what is this, month 11, month 12 of shutdowns across Canada. One thing to consider for employers when looking at policies related to COVID is whether you want to address travel in your policy. Right? If you've got a workforce who can't work from home, so effectively them traveling outside the province may result in them having to stay home and quarantine for 2 weeks. It's a good idea to make that really clear up front, or make it really clear up front that if you choose to travel for pleasure or as leisure to somewhere that's going to require you to quarantine when you get back, that, like Priya was saying, it might subject you to discipline. Just to make the rules clear up front. This is a time where it's during COVID where it's really hard to figure out the rules sometimes. So the more an employer can do to make it clear up front, the better it's going to be likely.
All right, I'll take another question here. So the question is, in terms of investigation on an employee's social media comments, which have an impact on the company's reputation, how far should the employer go, and what would be the recommended investigation process? So this would be like any other workplace investigation. You would want to give the individual an opportunity to respond to your concerns, confirm, whether or not they made the comments. Presumably someone has brought them to your attention, so if you haven't seen them, get a physical copy of them. Find out if there were any mitigating circumstances, and understand, where they were coming from before you make a decision to terminate. But the thing here is that you have to make sure that the individual has an opportunity to respond, and that you're able to confirm and determine that they did the thing that they're alleged to have done.
And that ties into the documentation point that we were talking about a bit before. If we can kind of underscore one of the points we talked about today, it would be document, document, document. Can't say it enough because remember, if you have to justify discipline or a termination for cause before an adjudicator, the way that you do it is, one, from a legal standard, did we do what we had to do? And two, can we prove that we did what we had to do? So this goes for investigations, this goes for discipline. So the more documentation we have in place to be able to prove it, the easier our jobs as lawyers is going to be, and ultimately hopefully a better result we can look for the employers.
Okay, so the next question I have is, what if the employer feels masks are not necessary in the office as we have 2-meter distance? Is this okay? So as I said earlier, you're entitled to determine what your policies are. And the regulations are, they set out that minimum threshold. If your policy is that employees have to wear masks in the workplace, then it doesn't matter if the employee feels it's not necessary, you're still entitled to enforce that policy. Hey, Tim, I'll pass that back to you.
Yeah, so I've answered my stack of questions, so I think we're okay for now, unless you have another one in front of you now, Priya.
All right, hold on, I just got some more questions in. Okay, so this question is regarding freedom of speech. What can you do if an employee talks about conspiracy theories and is sharing their beliefs in QAnon on breaks or outside of work? So this, this kind of comes back to that analysis as to whether or not the employee making these types of comments could be damaging to your reputation, or if they are inconsistent with the nature of their duties. So probably the most clear-cut example is where you work in long-term care, or if you work in healthcare. Having an individual espousing these types of views to other coworkers, to patients, or to any of your customer or client base, this could be damaging to your organization, and this could certainly result in discipline or termination. Okay, the next question I've got here is, what if an individual lies on the COVID screening process as they don't want to stay at home? Well, I mean, dishonesty is one of the key ways in which we are able to terminate an employee for cause, and I would say that that's an extremely serious form of dishonesty, particularly if they have had any kind of exposure to COVID-19, and this puts your staff at risk.
Yeah, so at this point, it would probably make sense to investigate the employee and then put the question to them, so why they asked. But it sounds like if they're lying and they want to enter the workforce, that means they should have been screened out. So to Priya's comment there, it is a safety concern. So it is one that we would definitely take very seriously.
Okay. All right, the next question I have here is, for individuals who report daily to an office, are they required to complete the self-disclosure screening daily? Yes, absolutely. Every time they enter the workplace, you want to make sure that you have a record that they have completed that screening protocol. This is something that is required by regulation. So those are all of the questions I have. Tim, do you have any?
Yeah, there's also the exit screen now for some workplaces. So another thing to watch out for, just to make sure your screening is up to date. But no, those are the questions I have too. I mean, thank you so much to everyone for joining us this morning.
Yeah, and I think we would just remind you that a copy of today's presentation and the video will be available on our website in a couple of days, if not by tomorrow. We hope you found the program helpful and informative. If we didn't get a chance to answer your question, please drop us a line. Or if you have a follow-up question, drop us a line. We're happy to answer your questions. Our next HR review will take place on Wednesday, June 9th, 2021. The topic's in the design phase, and we'll send an invitation out in due course. If you're on our mailing list, you'll get a notification. If you're not yet on our mailing list, get on our mailing list. You'll receive briefing notes, newsletters, invites to all of our events, seminars, workshops, etc. You can subscribe on our website. There's a big red bar at the bottom of every page. Finally, we'd be grateful if you would fill out the feedback form that you'll receive shortly after this presentation. Thank you again for joining us. Have a great day and stay safe, everyone.
Bye, everyone.